So now we are going to start SEBI LODR regulation, okay, or SEBI LODR regulation 2015. Now, what was the need for having a SEBI LODR regulation? What is the full form of LODR? What was there before LODR? How life has changed after LODR? Let's have a brief discussion about that. So whenever a company which proposes to get listed or it is already listed, okay, so these listed entities, they had to enter into an agreement with the stock exchange. With all the stock exchanges, they have to enter into an agreement. So let's say there is a company which wants to get listed at Bombay Stock Exchange. They want to get listed at National Stock Exchange, and then they want to get listed at, let's say, Calcutta Stock Exchange, right? So they have to enter into three agreement. One agreement with BSE, one agreement with NSE, and one agreement with the Calcutta Stock Exchange. Also, these agreements, there were separate set of terms for BSE, separate terms for NSE, and separate terms for the Calcutta Stock Exchange. Now to bring uniformity to all these things, okay, so that you don't have these multiple agreements and all, you have one uniformity, and that's the reason you have now only LODR and you don't have any agreement or listing agreement. So earlier what it was called as listing agreement, LODR is called as the listing regulation. This is there. Now what's the full form of LODR? LODR stands for listing and obligation, okay, listing obligation. So LODR stands for listing obligation and disclosure requirement. So what this regulation focus upon is basically on corporate governance, on disclosures, right, which a listed company has to do, because large number of people, okay, public at large has invested in this particular listed company. So it is important that certain decisions are taken by giving proper disclosure to all those shareholders. Also, uh, on a regular basis, which can be annually, quarterly, event wise, disclosures have to be given. So entire this LODR is with respect to your disclosures, what the company has to do. So you will find a lot of the terms like obligation. This is the obligation of the company. This is the obligation of the company. This is the obligation of the company. So you'll come across a lot of obligations which you are going to see, and that's what we are going to study about the LODR regulation. Now, if you see the breakup of LODR regulation from regulation 1 to regulation 3, that's the preliminary, which will also include the definitions, which is there and which we have to refer throughout the regulations. Then we have regulation number 4. This says that what are the principles, okay, the principles of LODR. The principles of LODR, you are going to find it here. Then from regulation number 5 till regulation number 14, this is the common obligation which is for all the companies, okay. This is the common obligation for all the companies. Each and every company has to follow this regulation. So this is there. Thereafter, you have regulation number 15 till regulation number 48. This is obligation for the listed company which has got specified securities. Okay. So this is going to be obligation for the companies having specified securities. Now, what is the definition of this specified security? We are going to cover this also. And in companies, whether it's all company or there are certain exemptions to certain classes of company, we are going to cover that. Thereafter, you have regulation number 49 to regulation number 62. This deals with the obligations of a listed company which has issued the non-convertible preference shares. Okay, so this is basically the obligation for the companies that have issued, okay, non-convertible preference shares or non-convertible debentures, right? So non-convertible debentures, non-convertible redeemable preference shares which have been issued. So that will be covered here. Then we have regulation 63 to regulation 64. So this is basically obligation for the non-convertible debt securities. Okay. The non-convertible debt securities would be again covered here. Now there are companies which has specified securities. So if you see here, non-convertible debentures or non-convertible redeemable preference shares, you will find both this here. But what is the difference? The difference here is here the companies, okay, if you see here the company has issued only non-convertible redeemable preference shares or only non-convertible debenture. Here the company has issued non-convertible debenture or non-convertible redeemable preference shares plus the specified securities. Make sense? Does this make sense?
Yes, sir.
Yes, sir.
Right? Then you have regulation 65 to regulation 80, which is for the companies that have issued Indian depository receipts. Then from regulation 81 till regulation 87, this is the obligation of the company which has issued listed securitized debt instruments, right? And then you have regulation 87A to 87E. This is for the security receipts. This is securitized debt instruments. This is for the security receipts. If you are going to issue security receipts, you will get it here. Then you have regulation 88 till regulation 91. This is for the mutual fund units, the companies which have issued. So we need not cover the entire part, okay, at least for your corporate funding exam, but this is going to be helpful for you to overall understand. And then you have regulation 92 to regulation 97, which provides what is going to be the obligation of the stock exchanges, right? All the obligations of the stock exchange that will be given here. And then you have regulation 98 to regulation 99, which provides what is going to be the action or the procedure of action in case of default, when the default takes place, right? And then from 100 till 103, it's the miscellaneous provision. So this is the whole structure of the entire LODR regulation. Does this make sense? So you need to understand that what all securities have been issued and which company falls into which category. And accordingly, you are going to comply with these regulations. Of course, like I mentioned, this is important because you need to understand what is the logic of LODR. So if you get a question in the exam, or if you want to understand what is the logic of LODR, or how LODR is driven, so we often say that the regulations or the rule has to be followed in the letter of law, spirit of law. So the spirit of law would be derived from here, okay, from the principles of LODR. Then regulation 5 to regulation 14, these are simple regulations, some common obligations for all the companies which has issued any securities. From regulation 15 to regulation 48, you have where the obligation would be if you have issued the specified securities. Then 49 to 62, if you have issued only the non-convertible redeemable preference share or the non-convertible debentures. And then you have 63, 64, which is for non-convertible redeemable preference shares or non-convertible debentures along with the specified securities. So this is how we'll cover. So we'll first understand what is this specified security. So this entire we are going to cover from the bare regulations that I have downloaded from the SEBI website. So one thing is sure that this is completely updated, right? Now, what we are going to cover is basically we will understand what is the meaning of this listed entity. They use the word listed entity. Okay, the listed entity. We will also understand what is the definition of specified securities. So this we will understand now, and thereafter, as soon as we cover any particular provision, the definition will pick up that time only. Like for example, when we will do regulation 23, at that point of time, we will understand uh, this regulation 23 of LODR. This deals with the related party transaction. So when we do regulation 23, at that point of time, we'll understand what's a related party or who all are a related party, and then accordingly we'll make it. So that will make more sense rather than we doing all the definitions now and then we connect the regulations there. So on that note, let's start with the LODR regulation. So in the LODR regulation, like I mentioned, let's first understand certain definitions. So one of the definition is of the listed entity. So what do you mean by listed entity? So listed entity means an entity which has listed on the recognized stock exchange designated securities, okay, which is issued by it, or designated securities which are issued under the schemes which are managed by it in accordance with the listing agreement between the entity and the recognized stock exchange. So this is basically when the listing agreement, like I mentioned that which was there before the LODR regulation, it's for that. And here you have the listed entity, which is the entity which is listed on the recognized stock exchange, the designated stock exchange. So this is what you're going to get it here. Is this clear? I hope I'm audible.
Yes, sir.
Okay.
Yes, sir.
All right. Then you anyway know what is the main board, right? So stock exchanges have got multiple boards. One is the main board, SME board, Innovators Growth Platform. So this is, we are talking about the main board. Now let's understand what is the definition of the designated security. So if you see designated security, so designated security means the non-convertible debt security, non-convertible redeemable preference shares, perpetual debt instruments, perpetual cumulative preference shares, Indian depository receipts, securitized debt instruments, security receipts which are issued by the mutual funds, and any other security as may be specified by the board. Okay, so this is there in case of the definition of the designated securities. Okay, now let's go ahead and we straight away start with the regulation number 4. And if there is any other definition which I feel I have to pick up. Okay, so this regulation is applicable to whom? So the LODR regulation is applicable to all the stock exchange, to all the companies which have issued their securities on the main board, or they have issued their securities on the SME exchange, and they have issued their securities on the Innovators Growth Platform. Now, of course, the provisions which are applicable if the securities are listed on the main board as compared to the SME exchange or as compared to the Innovators Growth Platform, the obligations can be different, but whether it is applicable, answer is yes. So this can be one of your exam question, that the LODR regulation is applicable to whom. So it is applicable if the specified securities, okay, is listed on the main board or SME exchange or the Innovators Growth Platform, right? And then if any non-convertible securities is issued, Indian depository receipts, securitized debt instruments, security receipts, units of the mutual fund, or any other securities which are there. Now, these provisions will become applicable to the listed entities on the basis of the market capitalization criteria. So like I mentioned, that there are certain regulations which are not applicable to all, especially within 15 to 48, you will find certain thresholds. You're going to find that based on this, this is applicable based on that. So it says that the provisions of these regulations which become applicable to a listed entity on the basis of market capitalization criteria shall continue to apply to such entities even they fall below the threshold. Now, a classic example of this would be, let's say there is a criteria which says that this particular regulation is applicable to top 100 companies based on the market capitalization. Now, you all know what is market capitalization. Market capitalization is the number of shares, okay, into the market price per share. Now, this market price per share keeps on getting fluctuating. Number of shares also increase, but market price also gets fluctuated. So let's say in financial year 1, let's say 2019, 2020, your market capitalization was such that you were within this top 100. Okay. But in the next financial year, either your market price crashed or the other company's market price increased way too high. Now, next financial year, you don't fall into the category of top 100 companies. Now, will the LODR regulation be still applicable to you? However, the regulation or that particular provision says that this is applicable only to the top 100 companies. Got my question?
Yes, sir. It will
So
be applicable.
it will still be applicable. It will continue to apply even if fall below the threshold. So once a particular provision is attracted by a company based on the market capitalization, that will continue to stay applicable to that particular company. Then it says that the provision of these regulations which become applicable to listed company on the basis of criteria on the outstanding debt, that is again the same principle. Now let's just see what are the principles which are governing the listing uh, disclosures and the obligations. So what's the logic? What's the logic here? These are pretty much self-explanatory points. Okay, there is nothing lot of jurisprudence around here. So this is a very self-explanatory point. So here it says that the informations will be prepared and disclosed in accordance with the applicable standards. So it wants to ensure the listed entity which has listed securities shall make disclosures and abide by it obligations under these regulations in accordance with the following principles. Okay, so it's that the informations are prepared and they are disclosed with the applicable accounting standard, and proper financial disclosures are made by the company. Also, the implementation of the accounting standard that is made both in letter as well as in the spirit in the interest of all the stakeholders. Then again, the listed entity will refrain from misrepresentation, okay, and ensure that the information which is provided to the stock exchange and to the investor is not misleading. So if you remember, if you study the PIT regulations, okay, the insider trading regulation, it clearly mentions that if there is any rumor with respect to the company, okay, then that rumor has to be clarified by the company as soon as possible to the stock exchange. For example, let's say there is a rumor that like last week there was a rumor that Mukesh Ambani is shifting to United Kingdom along with his family. Now this rumor, do you think will have an impact on the price of Reliance? If this rumor is being made, do you think it is going to put any impact on the price of Reliance? Pooja,
Yes, sir.
Yes, sir.
right? It is going to put impact, right? Why? Because all of a sudden there will be panic in the market that in where Mukesh Ambani is moving to United Kingdom, so a lot of investments would go out from India to United Kingdom. So all these can result in market manipulation, okay? And there will be, I would say, just was not getting that term. There will be market fluctuations, not even the word fluctuations, but yes, volatility. Yes, this will result in volatility. Any positive news or the negative news will result in volatility. So how the companies are and being made ensured, and it is ensured by the regulator that the company do not end up doing all these things, or if any such thing happen, then the entity, it's their duty to refrain from misrepresenting. So all the informations, all the disclosures which you see, whether it's under the takeover regulations, PIT regulations, so all the disclosures, whatever is done, however, in the takeover regulation, disclosures are not made by the company, but PIT regulations and all, if you see, and also all the regulation disclosures which are made by the company in the LODR regulation also. So this is all what this should not be misrepresenting, and it should not be misleading. Thereafter,
That is
the
why they had given the media release. No?
yes, that's the reason they had to give the media release. Otherwise, there would have been market panic and volatility would have happened, right? So any news, I'll tell you, 10 years back, I still remember this news was being made, circulated. That time, of course, WhatsApp was not there, but there was a speculation that Indian Oil Corporation, okay, or it was, yes, it was Indian Oil Corporation. So Indian Oil Corporation have they have found a oil reserve in Assam, somewhere in oil reserve. I was in Assam that time. So everyone had this speculation that Indian Oil has found some oil reserve in Assam. And what had happened, this news just broke out during the breakfast time, 7:30, 8 o'clock. And by the time markets opened, people started buying the share, right? And ultimately there was a upper circuit which was there on the Indian oil share price. Reason being, everyone thought that since they have received the oil field, so there is going to be a lot of profits in future. Markets anyway anticipates, and that's how they buy the shares and they sell the shares. So this thing had started, and then finally uh, the chairman of IOCL had to come once they had also given the disclosures to stock exchange and all, and then they made a press conference that there is nothing as such which is there. We have not found any oil reserve. So after that, again the share price has crashed. So this happens a lot because uh, of the incorrect information, the rumors and all. So that's the reason they say that one point of conversation from the company and the market would be a stock exchange. Now, if you see why these disclosures are made to stock exchange, it would be so easy if you give disclosure on CNBC. Like, how many of us actually go and read the disclosures on the stock exchange? Whatever we have to do, we either see Economic Times or Money Control or Bloomberg Quint, or let's say we check any business newspaper or their apps, right? Have you ever seen that there is a Bombay Stock Exchange app on which you see all these disclosures and all? So people don't do that, but still there is a standard point that has been given, because not everyone is going to read Economic Times, not everyone is reading Bloomberg Quint, not everyone is reading, so not everyone is reading the English version. Some of them may read the Hindi news or their mother tongue, whatever that vernacular language which they are acquainted to. So they do that only. That is the reason they say let stock exchange be the one point of conversation. Now, if you will say that stock exchange पे क्यों, वहां तो कोई नहीं देखता and all. So we say that you are trading on that particular stock exchange. So it is, you know, uh, that stock exchange you should do. Now, if you don't do that, that's your responsibility. But stock exchange where you are actually doing the trading, okay, we are giving you all these disclosures from our end. If you haven't checked, that's your fault. So that's how. Then again, the listed entity shall provide adequate and timely information to recognize the stock exchange, to the recognized stock exchange, and also to the investor. They will ensure that all the disseminations are made adequate, accurate, explicit, and timely, and they are presented in a simple language. So yesterday I was just listening to a webinar on related party transactions. So there someone from the proxy advisory firm, they were there who mentioned that uh, if the related party transactions are there, it's not that the proxy advisory firms are against the related party transaction. If the related party transaction is beneficial for the company, We also say that yes, it's good. The company should do the related party transaction, but again, the information should be provided. Complete information should be provided. What we expect is a complete disclosure, A, and B, that there should not be anything you know presented in a complicated language. It should be in a simple language that people can actually understand what is what, right? So that is where it's given here, that they should do all these in a adequate, accurate, explicit, and timely, and presented in a simple language. Now, again, the channel for disseminating the information shall provide equal, timely, and cost efficient access to all the relevant information by the investors. Now, it doesn't cost anything if you have to check any disclosure on the stock exchanges, right? That's because you just have to go to the website and do that. Now, let's say if it is like a paid subscription, then it becomes problem. So they have to ensure that information is provided equally to all the investors. And that's where we say that the information is to be provided to the stock exchange. Now, if you are reading, accessing the stock exchange there and then, it's good. If not, then there will be, if then it's not the fault of the company, neither the fault of the company nor the fault of the exchange. But if let's say you give information only on CNBC, and that time if you are watching Z Business, so there it becomes a problem. You would say that no, I was watching Z Business or I was watching ET Now, but you shared that information only on CNBC. So all those who were watching CNBC, they get the benefit and we don't get the benefit. So that's how they have this particular thing. Now the listed entity shall abide by all the provisions of the applicable law, including the securities law, and also such other guidelines as may be issued from time to time by the board and the recognized stock exchange in this regard. So this is not you something you have to mug up or you have to remember. This, just understand that these are the principles. Then the listed entity shall make the specified disclosure and follow the obligation both in letter as well as in spirit. Okay, so this is there. Then filing of the reports, statements, documents, whatever which are done, they have to be filed periodically and must contain the relevant information. Now you see this word relevant information, letter of law, spirit of law, all these are qualitative terms. So you cannot have a regulation. So it's same like the independent director. You can set up the criteria who can be the independent director, who cannot be the independent director. Same way, related party transaction, you can fit in that who is a related party, who is not a related party. But at the end of the day, if I say I transact with my cousin, okay, I transact with my first cousin, I transact with my second cousin. So as per the definition, the person would not fall into the category of related party. So the letter of law is filled, fulfilled, but the spirit of law is not. So these qualitative features you cannot put in. So how independent the independent directors are, this is again a question which is debated from time to time, that whether independent directors are actually independent or they get driven by the other factors. So these are some qualitative factors which are here. Then again, the periodic filings, reports and all have to be provided from time to time, so that the enable, right? This is to enable the investors to assess the current status of the listed company. Now see, as you see from a regulator perspective, regulator has made all the provisions, okay? But whether the investors, they actually follow that or not, that's their call. It's again like the nature has provided us many things, but do we actually follow the nature rule, or we actually destroy it, or we use the things in a way which becomes destructive for us? That's on us, on humans. Same thing goes here also. Take two examples. I'll give you two examples right now. Recent example is of the IPO of Paytm. Okay, now IPO of Paytm, you see it got crashed. Now the moment it got crashed, retail investors are like, ऐसा कैसे हो गया, listing gain तो हमेशा होता है, see Nykaa, right, we have got such huge gain, see Zomato, right? So the problem with that is, and if you see the response of the institutional investors, that was not that great as compared to the retail investors. In fact, Now, since we have also covered ICDR, we know that there is a reservation for employees, correct? When the company comes up with the public, before we calculate the net offer to the public, offer through the offer document, right? So if you remember, there is reservation for the employees. Now, in case of Zomato, the employees had not subscribed for the share, right? So same thing goes, for all such type of public issues where people actually don't invest on the basis of reading the prospectus. People invest on the basis of the brand. Okay, they felt that the Nike is a good brand, in long run there's going to be beneficial. They invested. Zomato, so Zomato, everyone know about Zomato, so people were like, good, so let's invest. So you get all those WhatsApp SMS that don't order that pizza of 500 rupees, invest that in the share of Zomato. 5 years later, you will have, 50,000 rupees. You can throw that lavish party out of that 500 rupees. So you get all those type of messages. Same way, uh, all the timely informations like the quarterly report, the quarterly financial statements, right? The annual accounts, all these things are provided to the stock exchanges. But instead of referring that to the stock exchange, what we do, we refer to the news channels. Okay, or of course we have to do, because those who are not acquainted with the, or those who are not financially acquainted with all these informations, right? The financial literacy is not there. Of course they have to resort to the stock exchanges, to these news channels only. But otherwise also, even those who are, how many of them actually read the financial statements and based on that they invest? There are very few. Otherwise, most of the investors you will find, they invest based on the recommendations which are given by the people around them, or on the television, or based on how popular the company is. So these are the principles which are being given in the LODR also. These are good, but effectively how strong it is, that's again a question which is again going to be a matter of debate. Okay, I'll share one screenshot from the public issue of, I think it was Paytm or it was Zomato. So in the DRHP, they had clearly mentioned about some issue. Right, I'll just share that, tell you. But none of them actually noticed. It was, yes, it was. So the DRHP reads out something like this. We have a history of net losses. We anticipate increase in the operating expenses in future, and we may not be able to achieve and maintain the profitability. This is the this is the exact clause which is written in the red herring prospectus. We have informed net losses for the last 3 years, including the restated total comprehensive income or the loss for the year, including discounted operations of 42,355 million, 29,433 million, and 17,040 million in the financial year 2019, 2020, and 2021 respectively. Further, it's written that we expect to continue to incur net losses for the foreseeable future, and we may not be able to achieve and maintain the profitability because of the market of our platform product services is evolving. It is difficult for us to predict the future results of our operations or the limit over the market opportunity. Now imagine this was written, I think it was Zomato. It was Zomato which had written this, and based on either Zomato or Paytm or Nika, either of the three had mentioned this, and see. So that's what goes here. Then in regulation 4 sub-regulation 2, you'll find that what are the rights of the shareholders. I'll not discuss all this. This you can just read it yourself. Just give a reading. It will hardly take a minute. Just do a reading about it. What is the rights of the shareholder? Then right of the stakeholder as this disclosure, transparency, then responsibilities of the board of directors. Just read it. Uh, just give it a reading once. Now let's start with the chapter 3, where I said you'll find regulation number 5 to regulation number 14. And it says that what are the common obligations of the listed entity. So first and foremost, it says that the listed entity should ensure that there are proper KMP, right? And directors, promoters, and other person dealing, they comply with their responsibilities and the obligations. Then you have regulation 6, which is a star point for us. What is the star point? The star point is that a listed entity shall employ a qualified company secretary as the compliance officer. Okay. And again, what is going to be the compliance officer? So now again, you need to understand the listed entity shall appoint qualified company secretary as the compliance officer. Now, the listed entity means the company which is listed its securities. Now, why this is important? Because does an intermediary require to appoint company secretary as the compliance officer? Is the intermediary required to appoint company secretary as the compliance officer? Answer is no. Why? Because then intermediary is not the listed entity. So if you're a listed entity, then you need to appoint a qualified company secretary as the compliance officer. Then you see the compliance officer of the listed entity, what is going to be the responsibility? So this is the responsibility of the compliance officer. Now, if you see, this can be one of your exam question. You need to ensure and confirm the regulatory provisions which are applicable, they are followed in both letter as well as spirit. You need to coordinate with the board. So that's why we say we do a lot of licensing work. So you need to coordinate with reporting with the board and to the stock exchange. So who is responsible for filing the information to the stock exchanges? It's the company secretary who does that. So your responsibility is to report to the board, then again recognize stock exchange and depositories and all other authorities with respect to the rules, regulations, and directives that come. They also need to ensure that the correct procedures are followed. Okay. And they also need to check the correctness, authenticity, and comprehensiveness of the informations and the statements of the reports which are filed by the listed entity under these regulations. So here is where you can again say, why does a company secretary signs the balance sheet? The financial statements are signed by the company secretary. And why does the company secretary sign? It is to ensure that the entire procedure has been followed with respect to the preparation of the financial statement. And again, it also authenticates the correctness of the information. And then also monitor the email address which is for the grievance division. So for all those investors, so mostly the investor grievance cell, which is there, you will find the company secretary, which is there. Now, provided that the requirement of this section, this regulation will not be applicable for the uh, units which are issued by the mutual funds, which are listed on the stock exchange, but they will be governed by the mutual fund regulations. So if the company, now if you see, it says the listed entity. So in the listed entity, even mutual fund comes into picture. But does mutual fund require to appoint company secretary and do all these things? Answer is yes, no. I don't know. For that, you'll have to check the mutual fund regulations. Is this clear? Is this point clear?
Yes, sir.
Okay. The next
Yes, sir.
point which you're going to see is with respect to the share transfer agent. Now, for the share transfer agent, you have two things. So either the company can appoint the share transfer agent, okay, or the company can manage the share transfer agent in-house. Now, what's the responsibility of the share transfer agent? What does the share transfer agent do? Registrar and share transfer agent. Are both of them same or both of them are different? Registrar and share transfer agent. CS executive. Capital market securities law. Capital market intermediaries. So registrar is the one who helps the company to prepare the basis of allotment and also prepare the list of the shareholders. Same thing goes here also. The registrar and share transfer is the person. Now, of course, earlier the person is registrar before listing. Once the company gets listed, the same person becomes the share transfer agent, provided they have the certificate of registration to act as both. Otherwise, if you have the power, or basically the registration can provide, the registration certificate can provide that you can act either as the share transfer agent or you can act as a registrar. So here it says that the company needs to appoint a registrar, the share transfer agent, or the company can manage the share transfer facility in-house. But the moment the number of security holders, okay, the moment the number of security holders, it exceeds 1 lakh rupees, okay, not 1 lakh rupees, 1 lakh in numbers, then in that case, the listed company will either have to appoint a registrar and the share transfer agent, or the company can also apply to register itself as the category 2 share transfer agent. Now, what is category 2? So like I mentioned, if you want to act as both, then you will apply for category 1. There you can be appointed as, so I'll just write it here, I'll be able to explain it better. So what happens? You have one person, okay? This one person is registrar and this one person is share transfer agent, okay? So registrar is before the public issue, and then after the public issue, this person can become share transfer agent. Now let's say there is A. He wants to be both registrar as well as share transfer agent. Then A is going to get the registration done under category 1. So under category 1, A can act as both. Then there is B, where I would say B would be registered under category 2. So in that case, either going to be registrar or is going to be share transfer agent. So if you see regulation number 7, by the way, is this part clear? I just quickly took it away. Is this part clear?
So category one, I didn't understand. Like why he will be like both. If after
So,
public issue is going to be share transfer agent.
so either, so if you want to act as both registrar as well as share transfer agent, right?
Yeah.
So for some companies, you want to become registrar, for some companies, you
Okay.
want to become share transfer agent, or for the same company itself, you want to be registrar and share transfer agent both. Then in that case, like it's like the different categories of merchant banker. So if you want to be
Okay.
uh, only the consultant, then you register yourself as category 4, right? So that's how you have 4 categories of merchant banker, correct? So each has got uh, a different role. However, category 1 merchant banker can do all the work. So same thing goes here. If you are a category 1, you can act both as registrar, you can act both as share transfer agent. Of course, at one point of time, either you will be registrar or you will be share transfer agent. But
Yeah.
so I think this was only your doubt, that if it is
Yes, sir.
clearly before and after, then how? Yes. So if you want to be registrar and you want to also be a share transfer agent, either for the same company before and after the public issue, or for different companies you want to be registered, and for some set of companies you want to be share transfer agent, then you need to apply for certificate of registration under category 1. Otherwise, you'll have to register for category 2. And in that case, either you act as registrar or you act as share transfer agent, and you can decide that. So that is where regulation 7 says that. Regulation 7 says that if the number of security holders, okay, if the number of security holder is up to 1 lakh, then in that case, company has the option. Either it can maintain the list of the shareholders, the security holders in-house, or they can appoint a share transfer agent. So there is an option. But the moment they exceed 1 lakh, okay, the moment they exceed 1 lakh, here the company again has the option that they can do it in-house or they can appoint a share transfer agent. But what is the difference? They can do in-house, but they need to obtain the certificate of registration, okay, of category 2. Category 2 share transfer agent. Is this part clear?
Yes,
Yes,
sir.
sir.
So this is what is being given here. So this is regulation 7. Okay. So the listed entities. Now, if you read the entire part, you'll be able to understand that the listed entity shall appoint a share transfer agent or manage its share transfer facility in-house only. But provided that in case of in-house share transfer facility, as and when the total number of the security holder of the listed entity exceeds 1 lakh, the listed entity shall either register with the board as category 2 share transfer agent, or they can appoint a registrar to an issue and a share transfer agent which is registered with the board. Is it clear?
Yes, sir.
Then it says that the listed entity shall ensure that all the activities which are related to the share transfer facility are maintained this and they are registered with the board. So this is fine. Also, the listed, so here is the compliance. Okay. The listed entity will also submit the compliance certificate to the exchange, which is duly signed by both the compliance officer of the company and the authorized representative of the share transfer agent, if applicable, within 30 days from the end of the financial year, certifying the compliance of this requirement. Is this clear? Is this clear?
Yes, sir.
Yes, sir.
Okay. Now, in case of change or appointment of the share transfer agent, the listed entity shall enter into a triplicate agreement between the existing share transfer agent, new, and the listed one. So if you are going to change the share transfer agent, you'll have to do this, right? And provided that in case the existing share transfer facility is managed in-house, the agreement referred to above shall be entered into between the listed company and the new. So this is basically if you are entering. So here it says that you need to enter into transaction with old, new, and company. Now let's say company was only handling it in-house. Then in that case, there is no old. Then there will be only agreement between these two. Okay. Otherwise, this is going to be the triplicate agreement. So this is fine. Then the listed entity will also intimate the appointment within 7 days of the agreement. So this is again the compliance, that the listed entity has to intimate about such appointment within 7 days from entering into an agreement, and the agreements which are referred to shall be placed on the board of directors. This is fine. The cooperation with the intermediaries registered with the board. Now here it says that the listed entity wherever applicable shall cooperate with the cooperate with and submit the correct and adequate information to the intermediaries which are registered with the board. Like if you see merchant banker, credit rating agency, registrar, share transfer agent, debenture trustee, all those things within the timeline. So what it is, this is again the obligation. So I'll keep on writing what is obligation, what is compliance. Okay. So this was compliance. This was compliance. This is purely obligation. Then it says that preservation of the documents. Again, this is what? This is obligation. Now, of course, obligation is also compliance, but this is the obligation that they should have a policy for the preservation of the documents, and documents should be kept for two categories. One which are going to be uh, kept prepared for, permanent in nature, and the other for not less than 8 years, right? Like the register of member have to be maintained permanently, and then some other documents they can be kept for 8 years. Then if you see filing of the information, so all these filings will be done on the electronic platform of the stock exchange. So where the filings would be done, it will be done here. For that, what listed company has to do, they has to put in place the infrastructure as which is required for the compliance with sub regulation number 1. So you have to put that on the electronic platform, right? So this is again basic scheme of arrangement. Now with respect to this, also read regulation 37. This will also be important for your corporate restructuring. Now what does it say? It says that the listed entity shall ensure that any scheme of arrangement or amalgamation or merger, reconstruction, reduction of share capital, all that is to be presented to the court or tribunal does not violate or override the limit the provisions of the securities law and requirements of the stock exchange. One is this. Now let's just quickly read regulation 37 also. Since we are discussing about it, I'll quickly take you to regulation 37. Yeah. So this is with respect to draft scheme. It says that without prejudice to regulation 11, listed entity desirous of undertaking the scheme of arrangement or involved in the scheme of arrangement shall file. Now, what is the obligation? The obligation is to file the draft scheme of arrangement, okay, which is proposed to be filed to the tribunal, right, uh, with the stock exchanges for obtaining the no objection letter before filing such scheme with the court or the tribunal. Is this clear? Is this clear? What is the requirement? Guys, is it clear?
Yes, sir.
Yes, sir.
So it says that the draft scheme has to be filed. So if you remember, we did it in the CRI also, that first the draft scheme is filed to the stock exchange, then you get a NOC and thereafter you file. So why? Because the draft scheme has to be filed first to the stock exchange. You have to receive a NOC. Then it also says that the listed entity shall not file the scheme of arrangement with the tribunal unless it has received. So I'll just highlight the relevant part. The listed entity shall not file. Okay. Alright. The listed entity shall not file any scheme of arrangement with any court or tribunal unless it has obtained the no objection letter from the stock exchange. And same thing goes here, that the scheme of arrangement has to be filed. The draft scheme has to be filed with the stock exchange and obtain the no objection certificate. Thereafter, it says that the listed entity shall place the no objection letter of the stock exchange before the court or the tribunal at the time of seeking approval of the scheme. So they also have to place, the listed company will also have to place the no objection letter which is received from the stock exchange before the tribunal, and then say, and what is the validity? The validity of the NOC is 6 months. Okay. Thereafter, it says that the listed entity should also ensure compliance with the other provisions which are given. Now, upon the sanction of the scheme. So all the compliances which you have with respect to the scheme of compromise and arrangement in the LODR is either before or after. So till now, we all were talking about before the scheme. Now it says that once the scheme is sanctioned, okay, it has to be filed to the stock exchange, right? Immediately. And then nothing in this section shall apply to the draft scheme which solely provide for merger of a company with a wholly owned subsidiary. So section 233. Okay. So if it's a section 233 merger, then in that case, no regulation 37 will be applicable. What you need to do, you just need to give the disclosure. However, the draft scheme shall be filed with the stock exchange for the purpose of only disclosure. So in that case, only disclosure, no NOC. Does this make sense? Then it says that the requirement as specified under this regulation and regulation 94 of these regulations shall not apply to the restructuring or the proposal. So again, here also if it is pursuant to IBC, then again, it is not. The only thing you have to do is disclose within 1 day of the resolution plan. So in case of IBC also, no NOC, only disclosure. Make sense? Does this make sense?
Yes, sir.
Does
Yes,
this
sir.
make sense? Right? So this is what is given in regulation 37. Now let's go back. So this is again important. This is again an important question from your exam perspective. So just understand, before you file the scheme to NCLT, you have to file the scheme to the stock exchange, obtain the no objection letter, and until you get the no objection letter, don't proceed. Once you receive the no objection letter, you have to submit that no objection letter to the tribunal or to the court when you are seeking for the approval. Okay. Thereafter, it says that the validity of the no objection letter is 6 months. That is, if you don't file your scheme to the stock exchange within 6 months, then in that case, you'll have to obtain a fresh no objection letter. Now the scheme is with the tribunal. Let the tribunal decide what is to be done and whether the scheme has to be approved, it has to be sanctioned or not. Once the scheme is sanctioned, then again you need to intimate it to the stock exchange. However, in two cases, it says that you don't need to obtain the no objection certificate, but you need to give the disclosure. One is if it's a merger between holding company and a wholly owned subsidiary company. Okay. So if it's a merger of a holding company and a wholly owned subsidiary company, then you need not uh, basically, then in that case, you need not obtain the NOC. You just need to intimate it to the stock exchange for the disclosure purpose. And the second is if it is under the resolution plan, okay, you are acquiring the company, then again, you need not intimate it to the, so I mean, you need not take the no objection certificate from the exchange. You all need to give is the disclosure. Now, does this make sense? Does this make sense? Now,
Yes,
since
sir.
we are
Yes.
here, we also check this, that the minimum public shareholding has to be maintained throughout. However, it is not applicable in case of innovators growth platform. This again, we studied while we did ICDR, that in case of ICDR, if the company is listed on the innovators growth platform without making the public issue, they have a lot of exemptions and they need not comply with the requirements of the minimum public shareholding. Okay, let's go back then from regulation 11. Now let's say we'll do regulation 12. Yeah. So payment of dividend, interest, redemption, and all this. So all the payments which you do, all these have to be done in the electronic mode only. they can use any electronic mode of the payment, right, which is approved by the Reserve. Now, very important, which is approved by the Reserve Bank of India. Can you give Bitcoins for dividend? Crypto. Can you give crypto Bitcoins?
No.
Answer is no, because it's not approved by. So any electronic mode, UPI and all, it all can be done with respect to the dividend, interest, and the redemption or the repayments of the amount, right? And provided where it is not possible to use electronic mode, the payment should be done through the check, right? And this should be account. So where the amount payable as dividend exceeds 1,500 rupees, the check will be sent only by the speed post. Otherwise, you can do it through the electronic mode. So nowadays, anyway, yeah, it's done by the electronic mode only. Then you have the grievances part. Now, grievance redressal. So this is with respect to the scores, right? So if there is any complaint, investor grievance, what the investor is going to do, what is the process? Does the investor straight away go to scores, or first the investor goes to the company? If there is so if you have a grievance, will you straight away go to scores, or you will first go to the company?
First
Company.
to the company.
First to the company, then you will, and even if you go straight away to the scores, scores is again route you back to the company only. It would say basic, it would not route you to the company, but it will route that complaint to the company, that this is the complaint that we have received, so what is to be done, and then accordingly you give a reply. So here it says that whenever there is any investor grievance, the company has to take adequate steps with respect to the expeditious redressal of the investor complaint. One is this. Then it says that the company also need to register itself on the scores, right? The company needs to register itself on the score platform. Then the company will also have to file. This is again the compliance. This is obligation. This is the obligation, and here it is the compliance. It says that the listed entity, okay, the listed entity shall file to the recognized stock exchange on the quarterly basis within 21 days from the end of each quarter a statement giving the number of investor complaints pending at the beginning of the quarter, those received during the quarter and which are disposed of and which remain unsolved. So again, like how you say opening plus what new plus what is resolved, right? And what is still pending. So this report has to be sent on a quarterly basis. Then the fees and the other charges have to be paid to the stock exchange as and when it is required. Now tell me, is this part clear?
Yes, sir.
Now you have chapter number 4. Chapter number 4 is the most lengthy chapter. You start from regulation number 15 and you end that at regulation 48. Now here it says that what is the obligation, and the obligation is with respect to the listed company which has listed its specified securities and its non-convertible debt securities. Okay. Now here if you see, there are many exemptions which are given. On this it is applicable, on that it is not applicable, right? So this part we will do later on. Okay, what is applicable where? This applicability part we will do elsewhere. Here, as of now, let's see, we will start with regulation number 17 because this is again important from your exam perspective. We'll check some of the definitions also, but just see what does regulation 17 says, that what should be the composition of the board of director. So it says that the board of directors should have an optimum combination of the executive and the non-executive director. Now tell me one thing, what is a non-executive director and what is the difference between executive and non-executive director? optimum combination of executive and non-executive director. So what is the meaning of executive and non-executive directors?
Non-executive directors do not take part in day-to-day management,
Mm-hmm.
like independent directors.
Mm-hmm. So independent and non-executive directors are same, or there is a difference between the two?
An independent director is a non-executive director only.
Okay. Can you say that all independent directors are non-executive? So I'll ask two questions. You have to tell me which of the statement is correct. Either both are correct. So I say all non-executive directors are independent. One statement. And the second statement is all independent are non-executive. Which of the following is true?
Second.
Second,
B.
sure.
Yes, sir.
Okay. So this is correct. This is wrong. So if you see directors, there are three categories of directors. One is your executive director and the other is non-executive director and the third one is independent director. Okay. Now when I say executive director, okay, executive director is the one who participate in the day-to-day functioning. He is in full-time employment. When it comes to non-executive director is basically there on part-time basis. Okay. Why a non-executive director is appointed then if he is on part-time basis? Because of the expertise, knowledge, experience. There can be anything. And why is independent director appointed? Because law requires. Very simple. Okay. And again, to ensure governance. Why law requires this? So that to ensure corporate governance. Now this non-executive director can be, okay, it is possible that this non-executive director was executive director and is now non-executive director. Or it can be possible that the non-executive director is independent, which means he was never, how do you say? I cannot use the word attached, but he was never associated with the company before. He was never associated with the company before. Now take for example, Mr. Ratan Tata. So Mr. Ratan Tata for Tata Sons he was executive, correct? But now he is non-executive, correct? But can Mr. Ratan Tata be independent?
No, sir.
Answer is no. He cannot be independent for Tata Sons. He can be independent for ITC. He can be independent for Reliance. That's a separate issue, but not for the Tata Sons. Okay.
Yes, sir.
Okay. So what does regulation 17 says?
Sir, it
Regulation.
is not necessary to appoint executive director. No? All directors can be non-executive also.
No, you need to have executive directors. You need to have
Okay.
executive director. So who is going to work then?
Okay.
If you have all non-executive directors, which means all of them are on part-time basis, who is going to work? Where have you read that you have to appoint or you need not appoint executive directors? Directors have to be appointed, na?
Sir, I am not sure, but I think in one of our companies, all directors are non-executive only, like non-executive and independent. So that is why I asked this.
Then I'm not sure. Then I'm not sure because you need to, then there must be some manager or a full-time
Yeah,
director.
there is a manager.
Yes, so there has to be so if there is a manager, then there is fine. Because
Okay.
so you need to have either a manager or a full-time director or a managing director in the company. Because otherwise who
Okay.
is going to function, the day-to-day functions will be held by whom, and then you can have the directors who can be independent, because companies act says that you need to have 2 directors and 3 directors, correct? So
Yeah.
even if you appoint independent director, so let's say I appoint one women director and I appoint one independent director, that is also enough. I've fulfilled my, in case I'm giving an example, though the provisions are not applicable to a private company, but I give you one example. Or let's say in case of a public company, I need to appoint minimum of 3 directors. So I appoint one managing director, then I appoint one small women director, and I appoint one independent director. Provisions is done. Or let's say I appoint one managing director, one small scale shareholder director, and one uh, women director. And women director, small shareholder director, both are independent. My purpose is solved.
Yes.
Right? So of course, so you need someone who is going to handle the day-to-day business. So law does not say that you need to have executive directors, but again, like I asked that there must be some manager. So you need to have a manager there. Okay. So the board of directors, what regulation 17 says that the composition of the board of directors, there should be an optimum combination of the executive and non-executive directors with at least one independent with at least one women director, and not less than 50% of the board shall comprise of the non-executive directors. Okay. Now again, if you see top 500, top 1000. So now anyway, this proviso is not applicable because it is top 1000 listed entities. They must have at least one independent women director. So the requirement of appointing one women director and one independent women director. So on the board, do you need 2 women directors, or with one you can handle both? Don't call me misogyny. Okay, this is not misogyny that I want only one women director, but I'm just asking from the legal understanding point of view. Just 1 minute. So so my question was that can we have one women director who can also be an independent director, and both the purposes are solved. Or do we need two women director? Muskan as women director, Pooja as independent director. Or we can have Muskan as both independent as well as the women director.
One woman director is enough, sir.
Right. One women director is enough, provided that one women director is also independent. You know why this logic was introduced? Because when it said that you need to have one women director on the board, most of the promoters, what they did, their mother or their wife, their sister, right, daughter, they all were made on board as the women director, right? So the purpose was not solved, therefore you had this proviso, and I'm not making it up. If you'll see, this proviso was inserted in 2019. Reason being that it was noticed that again the letter of law was being fulfilled, the spirit of law was not. So here it said that you need to have at least one women director who is going to be independent on the board. Okay. Then it says that with respect to the chairperson, so where the chairperson is non-executive director, at least one third of the board should be of independent director, right? And where the chairperson, okay, and where the listed company do not have a regular non-executive chairperson, then at least half of the board of directors should be independent. Then there is another case where the non-executive director, who is the chairperson, he is also the promoter, okay, or member of the promoter group or something. Then in that case, half of the board shall be of independent directors. Is this clear? Is this part clear?
Yes, sir.
Yes, sir.
Then minimum number of directors. So here if you see, the minimum number of directors in case of top 2000 listed entity should be at least 6 directors. Okay. Now, okay. So we discuss about the composition of board. So what happens in case of composition of board? You need to have a combination of executive and non-executive director plus one women director who should be independent. Okay. Thereafter, you need to see who is the chairperson. The chairperson is the executive director. In that case, half of the BOD should be independent. If the chairperson is non-executive director, then you need to see how one third of the BOD should be independent. Thereafter, if this non-executive director is the promoter or from the promoter group, then in that case, half of the BOD should be independent. Does this make sense? And top 2000 companies, they need to have a minimum of 6 directors on board. Okay. Okay, important. This is important. They are, or they may ask you with respect to the composition of the board, right? Is this clear?
Yes.
Yes, sir.
Okay. Okay. Now, you have, okay. If there is going to be any person who is going to be appointed as the non-executive director, and the person has attained the age of 75 years, then that person has to be appointed by way of special resolution. And in the explanatory statement, right, it should indicate the justification for appointing such person. A very classic example for this is Mr. Deepak Parekh. Do you know who is Mr. Deepak Parekh? Do you know who is Mr. Deepak Parekh?
No, sir.
You should know. He is the person, Mr. Deepak Parekh. Okay, a very, very renowned personality. So right now he is non-executive chairman of the HDFC. Okay, now I will tell you uh, appointment opposed by proxy advisors. You'll get this. There is going to be a news. Yes. So this was the news. HDFC investors voted against me due to my directorship in many firms. But there was this case that proxy advisors has also voted against because his age was 75 years, right? So they said that no, we should not vote in favor of this. So Deepak Parekh will turn 74 this year, and he will continue till 2020, and thereafter this news was there. So just remember, whenever this news comes, I always have due to age or special resolution. There is this article which is there, not 2018, it was 2019 news which was there. And there were 22 or something, yes, as many, 77% voted in favor and 22% voted against the continuation. And the reason which was there, see, HDFC had to come out. Can you read this? Can you read this part?
Yes, sir.
Yes, sir.
HDFC had to come out with the special resolution for the reappointment of Parekh as he would cross the age of 75 in this. And that's where, companies, they, you know, so the resolutions were voted against. And for others, if you see, it is voted in favor. So Mistry got 99.51% votes as the shareholder, as his reappointment was through the ordinary resolution. Does this make sense? So this always reminds me of Mr. Deepak Parekh. Okay, because it was quite surprising that a person like Mr. Deepak Parekh, proxy advisory firms were opposing that he should not be appointed, because today what HDFC Bank is because of Mr. Deepak Parekh. So anyway, now this is a controversial amendment which is there. It was supposed to be there last year only, but see, if you will see 76, it has been substituted for 1st April 2020. So last year in the sense, I mean, the COVID wala year. Okay. So it had to be done in 2020 only, but now it has been changed and now they have made it from 1st April 2022. Most probably, I feel that there will again be an extension which will be given for this. What does it say? Most probably, I am not sure, and it should not come. But again, if you see, it says that top 500 listed entity, okay, they shall ensure that the chairperson of the board of the listed entity shall be non-executive director and not related to the managing director, chief executive officer, as per the definition of relative, okay, defined in this. Now, Pooja, in your company, you will face this challenge. Reliance. Right now, Mr. Mukesh Ambani is the chairperson, correct? He's the CMD.
Yes, sir.
Now, with effect from 1st April 2022, either he will be only the managing director, he cannot be the chairperson. There will be split of this position of CMD. So now you will not find a position called as CMD, and there will be a split. Now, why this was the delay was given for 2 years? Because they said that since it's a COVID pandemic, now we need some time, you know. Mukesh Ambani, I'm giving an example of this. It's not that just because of Mr. Mukesh Ambani the regulation got changed. But let's say Mr. Mukesh Ambani, if you see, he would say that I am currently holding the position of chairperson and managing director. Now I will continue to be the managing director, but I need someone who is responsible, or who is that responsible that he can handle the work as a chairman of the company. So you need to give me some time, and that's where SEBI said that okay, we give all the listed companies 2 years time, because this is going to be the problem with all the promoter based company, whether it's Reliance or it's Adani or it's uh, Birla Group, right? ABG Group, any company, if you see, you'll face this problem, and that's the reason. So this is the breakup of the position of CMD. Now you have chairperson and the managing director, which is there. However, again, companies like L&T, ITC, they don't have this problem because there is no identifiable promoter. Is it clear? No, this is an part of the amendment. So again, lot of articles were there that can uh, Mukesh Ambani now continue as the CMD? क्या होगा उनका? News में ये सब आ जाता है. This is there. Then it says that the listed entity shall ensure that the approval of the shareholders for the appointment of a person on the board of directors is taken at the next annual general meeting or within. So this is fine. Now this is with respect to the board meetings. Now there should be at least 4 times there should be a board meeting with a maximum time gap of 120 days between the two meetings. Okay. What should be the quorum? The quorum should be 1/3 of its total strength, or 3 directors, whichever is higher, which should have at least one independent director. Now this quorum is common for all. Everywhere you will find this quorum, right? Then it says that the directors who attend through video conferencing or others, they will also be counted as for the quorum. Remember this. Through video conferencing or by other audio visual means, they will also be counted for the purpose of the quorum. Then the board of directors will again have to periodically review the compliance report pertaining to the laws which are applicable to the listed entity, right? And if there are instances of non-compliance, they'll have to take the steps. The steps have to be taken by the listed entity to rectify the instances of the non-compliance. Then it says that the board of directors of the listed company shall satisfy itself that the plans are in place for succession of orderly succession for the appointment of this. So basic point need not relevant for your exam. The board of directors should lay down the code of conduct. That's the basic point. So the ones that the ones that I'm underlining, those are important, and the ones that I've just ticked is just okay for your knowledge. Then they should have a proper code of conduct for the independent directors. What are the duties of independent directors? Then the board of directors shall also recommend all the fees and compensations that has to be paid to the non-executive directors, including the independent director, and shall require the approval of shareholders. So remember, the sitting fees and the independent directors remuneration, all of that would require the shareholder approval. Then the requirement of this approval shall not be for the sitting fees. So the if you are paying only the sitting fees to the non-executive directors, and if it is within the limits, then it is fine. Then the minimum approval for the stock options, right? So the limits will be there applicable for this. This is fine. Then the approval of the shareholder by way of special resolution will be there if the any remuneration which is paid to a single non-executive director, it exceeds 50%. So this is also fine. The independent directors will not be entitled to any stock option. This is same like your Companies Act. And the fees and all which is to be paid to the promoter or promoter group, that will be by way of special resolution if the remuneration exceeds rupees 5 crore or 2.5% of the net profits of the listed company, whichever is higher, or where there is more than one director, the aggregate remuneration exceeds 5%. Important. This is basically remuneration to the promoter director, right? And then CEO and CFO should provide the compliance certificate. This is all fine. They should do risk assessment, risk policy, evaluation of the independent directors will be done by the board. So this is again one important part. This is basically the evaluation. It's the evaluation of the independent directors. Okay. So the evaluation of the independent directors will be done by the entire board of directors. They'll find what is their performance and fulfillment of the independence criteria. And remember, they had to company had to prepare a code, so that code is being complied or not. So this is there. It's fine. Maximum number of directorship important. So in how many companies you can be the director? So you cannot be a director in more than 8 entities here, and now it is 7. So for you all, it is 7. So maximum number of directorships, it is 7. Maximum 7 listed companies, provided that a person shall not serve as independent director in more than 7 listed entities, right? Now, if you are serving as a full-time director or as a managing director in any listed company, okay, then you should not act as an independent director in not more than 3 listed company. So the full-time director, managing director cannot act as an independent director in more than 3 listed companies. So this is again important. Now you come and we come to this point, which is the audit committee. Now this is super duper important. So every company will have to constitute a audit committee. Okay. And so every listed company needs to constitute this audit committee. Even this is required under section 177, okay, of the Companies Act. And this audit committee should constitute of qualified and independent audit committee, and there will be minimum 3 directors. In case of audit committee, there should be minimum 3 directors, and at least 2/3 of the audit committee should be independent. Okay. And if the company has issued superior rights equity share, then all the directors should be independent only. All the members should be financially literate, and at least one member should have accounting or financial related management expertise, right? Then the chairperson has to be definitely independent and has to be present at the annual general meeting to answer the question of the shareholder. Then company secretary to act as the secretary of the audit committee, and audit committee will have the discretion. At its discretion, they can invite the finance director or the head of the finance function, or the head of the internal audit, or a representative of the statutory auditor to be present at the meeting of the committee, right? So this is there. Then they should meet at least 4 times in a year with not more than 120 days gap between the two meetings. Quorum will be 2 or 1/3 of the total strength, whichever is higher, with at least 2 independent directors. Now, of course, if all the directors are independent, then this particular provision will have no significance. Then it says that the audit committee shall have the power to investigate. So if there is any reference which is received from the employee, or they can also take legal opinions. Basically, they have all the power to obtain legal opinion or professional advice. Then role of the audit committee will be reviewed as per this schedule. So this is fine. So just remember, in case of audit committee, what is going to be the constituent of audit committee, and especially that what will be the bifurcation, and also you need to have a clear idea about it. Clear? Is this clear?
Yes, sir.
Okay.
Yes, sir.
So next we have is the nomination and the remuneration committee. So this is another important question from your exam perspective. So nomination and remuneration committee, again, there will be at least 3 directors. Okay. All directors should be non-executive directors. 50% of the directors should be independent. And if there is SR shares, then 2/3 of the board should be independent. Chairperson has to be independent only, right? And quorum will be either 2 or 1/3 of the committee, whichever is greater, and it should include one independent. So this is same like audit committee. Okay, this is same like your audit committee. Then the chairperson of the nomination and the remuneration committee should be present again in the annual general meeting, same like this. But the nomination and remuneration committee should meet at least once in a year. So there is only one meeting which is needed minimum. They can meet more, but they need to have at least one meeting in a financial year. So what is the different between no, what's different in the nomination remuneration committee as compared to audit committee? Given the fact that you remember audit committee properly. So here you see again you need 3 directors. There also you need 3 directors. There it says that your 50%, like if superior right equity shares are issued, then all of them should be independent, correct? Here it says that 2/3 should be independent, correct? If you see the composition, if you see composition here, it says 2/3 should be independent, and if it is superior right equity shares, then there should be only independent directors. Here it says that at least 50% of the directors should be independent, and if superior rights equity shares are issued, then 2/3. So this is one different. Okay, so I'll just put a star mark here so that you remember this is different. Otherwise things are same. Chairperson has to be independent. This is same like your audit committee, right? Then the quorum is same. Then the chairperson has to be present into the meeting. This is same. Now this is again different. There 4 board meetings, 4 meetings of the audit committee. Here it is only one. Is it clear? Is it clear?
Yes, sir.
Okay.
Yes, sir.
So this way you will not get confused. So if you get a question, then you'll be able to remember this. Now again, pick up this stakeholder relationship committee. So stakeholder relationship committee. So this will be for all the types of securities. Now the chairperson of the committee has to be non-executive. Now again, if you see, at least 3 directors should be there. So this is same for all the 3, right? At least one being independent. And it says that if the company has issued superior right equity shares, then 2/3 of the stakeholder relationship committee should be of independent directors. So this part is same like your NRC, right? The chairperson shall be present at the meeting. This is again same. They should meet at least once in a year. So this is again same like your NRC, right? And the role of the stakeholder relationship committee is again specified in part D of the schedule. So we'll rate it there. Then you have the risk management committee. So the risk management committee should again have minimum 3 directors with majority of them from the members of the board. Now this is again different. Majority of them should be from the board of directors, and there should be at least one independent director. And if superior right equity shares are issued, then 2/3 of the risk management committee should be independent directors. Thereafter, you see, the chairperson of the risk management committee shall be the member of the board of director and senior executive. This is fine. They should meet twice a year. The risk management committee should meet twice a year, I think. Yes, this amendment is applicable for you all, right? So you should meet, the risk management committee is going to meet twice a year, and there should be either 2 members who is going to be the quorum, or 1/3, including one independent director or one director from the board that should be there. And again, the meeting should be conducted in such manner on a continuous basis. Not more than 180 days must have elapsed between the 2 consecutive meetings. So technically, if you see, you should have at least 2 meetings, 2 risk committee management committee meetings in a year. But it's written in a different way. They say that you should have it on a continuous basis. So as and when required. So it is on SOS basis, but again, not more than 180 days gap between the 2 consecutive meetings. The role and the responsibility will be again specified, right? And you have to see part D of schedule 2. We'll read schedule 2 also. Then it says that the provisions of this regulation is applicable to the top 1000 listed entities, and that's it. So remember, risk management committee is applicable for top 1000 committee. At the end, when we will finish LODR, I'll make a chart that this is applicable here and this is applicable for whom. Then you have vigil mechanism. So vigil mechanism is basically your whistleblower policy, okay, for the directors and the employees to report the genuine concern. And this is going to provide safeguard, okay. The objective is to safeguard against the victimization of the directors or the employees of the company who avail this part. Till here, is it clear?
Yes, sir.
Till here it is clear?
Yes, sir.
Okay. तो यहाँ पे related party transaction onwards, we will do it in the next lecture. Okay. From here onwards, we will do it in the next lecture. Most probably, I'll keep your lecture tomorrow only. I'll inform you the time. And if not, then we'll have our lecture on Thursday. Okay.
Okay, sir.
All right then. Take care. Bye bye.